Ms Hazel Tunney, Qualified Irish and European Trademark and Design Authority. Over to you.
Cathaoirleach, members of the committee, ladies and gentlemen. My name is Hazel Tunney and I am a partner of Tompkins & Company, one of Ireland's oldest intellectual property firms. We specialise in advising on trademarks, design rights, patents and, to much lesser extent, copyright. And around 30 years ago, my firm provided advice to the Government with respect to the protection of the harp as one of the national emblems of Ireland. I've been asked by Senator Daly to provide my observations and suggestions from the perspective of trademark protection and the types of protection enjoyed by the national symbols of the state, and have considered whether such protections could be extrapolated to encompass or in any way to be considered analogous to the types of protection which could be considered to protect the national anthem. Irish and international trademark law gives state emblems and flags certain rights and protections. In Ireland, this includes both the flags and national emblems of the nation and those of other nations as well. Ireland has notified WIPO, the World Intellectual Property Organisation, of a number of its official national symbols. These are a variety of different representations of the shamrock and of the harp. The registration of such emblems with WIPO gives them certain protections both domestically and abroad. Under Irish law, the registration of any trademark, and a trademark is a right that gives you an exclusivity in it, which consists of or contains any state emblem of Ireland or anything that can be mistaken for such an emblem, cannot be registered unless the consent of the Minister is secured. Any trademark which consists of or contains a representation of the national flag of the state as defined in the Constitution cannot be registered if it appears that the use of that trademark would be misleading or grossly offensive. So to summarise that, third parties cannot get trademark rights in anything which includes any state emblem or the national flag or anything similar to them unless permission is granted by the Minister, and only then if use of that mark would not be offensive or misleading. The Trademarks Act prevents the unauthorised use of Irish national symbols, which are the harp, the shamrock and the flag, or anything closely resembling them in connection with any business, if it is intended that use in this way would lead to the belief that the person or the business was authorised by the state to use those symbols. The Act empowers the Minister to take injunctive action against any such deceiving use and sets out a variety of fines associated with them. Ireland is party to the Paris Convention, which is a 19th century convention for the protection of intellectual property. Article 6 ter of the Convention allows for the protection of various emblems and insignias of the member states of the Convention and of their flags as well. Most member states have notified WIPO of their national emblems, and Ireland, as I said, has notified WIPO of the harp and of the shamrock. And as a result, any trademark which consists of or contains the flag or notified emblems of any convention country or anything which imitates them cannot be registered as a trademark in this country or any other country without the authorisation of the competent authorities of that country. If a certain sign is identical with or similar to a state flag or a protected national emblem, and its use is likely to mislead the public or to suggest a link with that nation where no such link exists, that state is entitled to prevent use of the sign by seeking an injunction. So to summarise all of that, unauthorised, misleading or confusing use of certain state emblems or the flag of Ireland and those emblems and flags of other nations can be prevented from achieving registration, and use of signs which are identical with or similar to a flag or one of these emblems can be prevented if that use is misleading. National emblems are signs that have symbolic meaning to or represent a country. A national anthem is a song which is usually officially adopted by a country, which acts as an expression of its national identity. In much the same manner as a national emblem, an anthem exemplifies or identifies a nation. As the harp and the shamrock represent Ireland, so too does our own Naveen. There is an argument that the Irish national anthem should be officially adopted, enshrined in legislation, and afforded some sort of protection similar to those granted other national emblems of the state and the Irish flag. If the committee is minded to consider adopting some sort of national anthem bill, my recommendation is that it looks to the types of protections afforded the flag, the harp and the shamrock by way of guidance. My initial thoughts are that the main attraction of such a bill would to be officially adopt and enshrine in legislation what the national anthem is, its musical notation and its various translations. And the beauty of bringing something in, like as a result of a consultation like this, is that we can also incorporate different translations, such as Irish Sign Language and any other translations which are deemed appropriate. As the Minister and as Dr O'Dell have said before me, such a bill can go on to be very non-prescriptive in nature. It can delineate between acceptable uses of the national anthem or less acceptable uses or non-acceptable uses, and looking to the types of protections granted to the flag, the harp and the shamrock can be useful. The existing protections for the harp, flag and shamrock include the requirement in some circumstances to seek the consent of the Minister to register them as trademarks, the ability of the state to take action to prevent unauthorised use if it's going to create serious confusion or suggest links where no such links exist, or if its use is going to be grossly offensive or misleading. I do appreciate that there can be concerns that such a bill would be overly prescriptive and determinative, but when we look to things like trademark law, an awful lot of the wording is quite subjective in nature and quite general. I appreciate that using words like misleading, confusing or grossly offensive they can be very subjective matters, but the use of subjective words like those does ensure that any type of bill like that would avoid being overly prescriptive because of the subjective nature of the possible words. Any such a bill can focus on using suggestive words like should or could rather than prescriptive words must or shall. That will assist in making any type of bill less prohibitive and really more guiding in nature. So my recommendation would be that any proposed bill, if the committee decides that that is the most appropriate way to proceed, incorporate provisions which provide a full, detailed definition of the national anthem and its various translations, contain general, non-prescriptive statements that the national anthem shall be reproduced, treated and performed with dignity and with respect, and not in a way which is misleading, confusing or grossly offensive. It could set out general provisions for seeking permission to use the national anthem in certain circumstances, like Dr O'Dell has said, in a commercial fashion, but making clear exemptions for non-commercial use, such as for charity and at the end of matches and so on. And if it is deemed necessary, provide for injunctive powers to prevent grossly offensive use or deceptive misuse of the national anthem. I thank the committee very much for taking the time to invite me to these proceedings, and I'm open for any questions later if anyone likes. Thank you.
Thank you very much.